dealing with a healthcare security breach that's raising serious concerns about how private medical information is stored in BC.
For more than half a century, the Granville Bridge has shouldered the load of millions of vehicles. But documents obtained by the CBC show that while there is no indication of immediate danger, there are concerns.
The documents include highly confidential information, people's names, birth dates, addresses, and phone numbers.
That's just not acceptable.
BC's Privacy Commissioner has launched an investigation.
Vancouver's police department is looking at cameras as a solution to the problem. It has plans to put 23 surveillance cameras throughout the area.
It's a cliche, but we now live in an information society. And we need rules about how that information is used and disclosed. And we need rules that are clear, that establish the correct balance. And the legislation that was established in BC was done for that reason.
It was a priority because I was used to government. I'd been on Vancouver City Council for 14 years as a mayor and as a member of the council. Called them aldermen in those days. And so I was used to people having access to information and for government being accountable. And I was kind of puzzled as to why anybody would object to it. So I just made sure that they realized that if you want me to be your leader and you want me to be the premier, this is the direction we're going. But it was also the leadership of Colin Gableman as the Attorney General, who was a non-lawyer, who believed in the same thing that I did. So I'd say that Colin and the officials in the Attorney General's ministry who helped draft the legislation were absolutely essential to it being drafted, coming before the legislature, and being approved.
This bill will strengthen the public's right to information and records in the hands of government agencies, boards and commissions, and crown corporations. It does more than simply open government files. It makes it very clear that government is the domain of the public.
There were many groups who wanted more access to government information. No question, because they were feeling the lack of it. They were feeling disempowered, they were feeling ineffective, they couldn't achieve their goals without better information to work with. And with all this grist for the mill, we created this group, the Freedom of Information and Protection of Privacy Association. We incorporated as a society. We received core funding from the Law Foundation of British Columbia, and that was absolutely key. We could not have done anything without that. And with that, I became the first president of the group, and we proceeded to do our work.
The people that are involved in pressing for it at that time, the civil society organizations, the activist groups, some people in the media like Vaughn Palmer, who were pushing for this as a foundational part of a good, healthy democracy. To have that sort of wind filling our sails as we move forward was very helpful for us to be able to introduce it, to overcome some of the doubting Thomases that didn't want to see freedom of information happen.
I've had a request for these reports. This one isn't on the list of information we routinely provide.
Is the requester waiting?
He's at the counter.
Okay. I need to check this out a bit further with the new manager, Information Privacy. Do you think you can wait a few minutes?
I'll go see.
Thanks.
Now it's a matter of course. It's like wearing a wristwatch. You just take it for granted now. And it was like when we brought in question period or Hansard. People take it for granted now. But that's a good thing, because they should take it for granted. You should be doing these things to open up the opportunities for the opposition to grill the government and for the media to have access to put the government's feet to the fire, or the opposition as it may be, and for citizens.
It's colossal amount of difference. Again, this whole sense of trying to understand, having an umbrella approach to what constitutes privacy and access, as opposed to, again, the alternative model is a higgledy-piggledy approach or a patchwork approach. That's absolutely critical, because it raises the specter for people that there are privacy rights everywhere, that there is an access to information component to all aspects of government. That is the door opening for people to understand that they do have rights and that they can exercise them.
I think it's achieved greater openness inside government. It's helped drive some of the initiatives that we see in BC and elsewhere towards open government, more sort of voluntary, proactive provision of information to the public. And I think that's been driven by the legislation and an awareness on the part of governments, including here in BC, that it's better to get the information out there rather than have to be asked for it.
There's a lot of major stories in this province that I've written or that others have written that simply would not have been broken without the FOI Act. A good example, I think, is the stories that we ran a few years ago about the BC Lottery Corporation. Inspired by a similar controversy in Ontario, we filed some requests about lottery retailers who had been winning prizes, and we discovered that they seemed to be winning prizes at a suspiciously high level. Another one, which we won a Webster for, was the daycare and nursing home inspection records. I discovered that they had this data, and instead of just writing a story about how the data wasn't public, that was one of our first situations where we actually FOI'd the data, and then we made that data available on our website. So you could go to our website, and you still can type in your kid's daycare, type in your mom's nursing home, and see what the inspection priority rating for that place is. And since we've done that, the health authorities have made more of their inspection data available online, but I don't think they probably would have done it as quickly if they hadn't been pushed by the stories that we did, which were based on FOI.
The Freedom of Information Act is present in any of the major scandals that we have experienced in British Columbia over the last 20 years. It's there. Somewhere there's some access to records and a decision about whether those records should be provided.
A stack of internal budget forecasts released under BC's Freedom of Information law shows the government was told repeatedly by its officials that the budget was headed for a big deficit. But Clark went to the polls claiming the budget was balanced.
We've been very clear with regard to the HST. It was not anywhere on our radar as we went through the election.
An insistence government did not have any plans to impose the tax until after the vote. But documents obtained under the Freedom of Information Act tell a different story. They show as far back as January of 2009, politicians were being briefed on the issue.
And often, of course, the politics surrounds not the substance of the issue, but the question of secrecy and openness, right? So the issue is not whether politicians have done the right thing or the wrong thing, but whether they have been secretive about doing those things. And that often becomes the lead story in the media.
It's not just that we're doing things differently, it's that things are different. And when we look at what we're about to see, and not just the internet, but the Internet of Things, where all our devices are about to talk to each other and the world at large, we're dealing with terra incognita here. We really haven't been to this place before.
On the one hand, technology has created great innovations. People have developed new services, new applications to make our lives better. At the same time, those that want to infringe on our privacy are emboldened to do so with these new technologies. And I think if you look at what's happening with the NSA, the PRISM issue, surveillance technologies, and the processing of information in secret, that's a huge, huge issue for personal privacy as we go forward in the 21st century.
The challenges to personal privacy go up and down like a yo-yo. And every new technology, going back to the invention of the camera, the telegraph, the railroad, and telephones, particular copying machines, cameras, have all thought to pose just fundamental challenges to personal privacy. Privacy is going to disappear. I'm confident, as an historian and student of human rights and the protection of human rights, that privacy will perhaps evolve. People's attitudes towards it will evolve. Certainly, I used to say in the early 90s, everybody's got to be their own privacy commissioner. That's even truer today.
I think more research is needed to find ways to protect individual privacy in the modern electronic world.
We need to assess the legislation in light of the reality on the ground. How are we going to hold true to the spirit of the legislation, given that, well, frankly, we didn't used to have personal devices you could circumvent these things with. Now we do. What are we going to do about it?
It would be better, I think, in my view, if the Act actually did include language that specifically recognized that we now live in an age of data and that FOI isn't just something to do with photocopies.
I've called for a duty to document, and I've called for new policies and technology changes to make sure that government information stays in government networks. I think this conference is really important because it's an opportunity for us to celebrate the past, to look at the fundamental principles in the law, where it's come from, examine the challenges in front of us with an eye to reform in the future. So how do our laws and our policies need to change to ensure that we still have these very important rights as we go forward into the 21st century?